The petition was only 3 pages long, but its goal was absolute: to have a court declare the old soldier mentally incompetent and strip him of control over everything he owned. And it was filed by his own daughter-in-law. By pure chance, the case was assigned to a judge who had served in the same unit with the patriarch decades earlier. The target was a 71-year-old retired Army colonel, a man used to giving orders, not having his entire life's freedom and fortune put on trial. The legal machinery was now in motion to seize his assets, his home, his very autonomy. But this wasn't just any judge reviewing the evidence. This was a man who had once followed him into combat. The question was no longer about mental competence. It was about loyalty, memory, and which version of the past would determine one man's future. Colonel James Thorne had built his second act with the same precision he'd used on patrol. After 30 years of service, he'd taken his pension and a nest egg of just under $200,000 and invested it into a chain of 3 surplus and tactical gear stores across Texas. The business, called Fortitude Supply, thrived. It catered to veterans, preppers, and law enforcement. By the time he was 65, it was generating over $1.2 million in annual revenue. He owned his home in Austin outright, a rugged stone and beam house on 2 acres, paid for with cash from the sale of his first store's location. His life was orderly, disciplined, and solitary. His wife, Eleanor, had passed from cancer a decade prior. His only son, Michael, was an architect living in Denver. The change began subtly about 3 years ago. Michael met Clara during a project in Dallas. Clara was a financial planner, 15 years younger than Michael, sharp, ambitious, and charming. James approved when they married. He saw her drive as a good balance for his sometimes dreamy son. After the wedding, Michael mentioned Clara was thinking of shifting her client focus to elder financial security. A growing niche, she'd said. James offered to be her first local client, to help her build a practice in Austin. It seemed a natural way to support family. Clara's involvement started professionally. She helped him restructure some investments, set up a more efficient billing system for the stores. She was good. Profits edged up. Then, about 18 months ago, Michael was diagnosed with multiple sclerosis. The progression was slow but definitive. The long-term prognosis meant he might eventually need significant care. Denver's winters were hard on his symptoms. The idea was floated gently by Clara. Maybe they should move to Austin. To be closer to family. To help with the business as Michael's architecture work became less reliable. James saw the logic. He'd built a guest house for visiting veterans groups. It was empty. He offered it to them. They moved in. Clara's help with the business became daily management. James, then 70, was happy to take a step back. He trusted her. She began talking about succession planning and asset protection. She suggested placing the business and the house into a family-limited partnership to shield it from potential future lawsuits or, as she put it, predatory nursing homes. It sounded prudent. He signed the papers she put in front of him. The first set, anyway. The first real flicker of doubt came on a Tuesday morning last October. James had a standing breakfast every week with his store managers. Clara called him at 7. "James, don't bother driving downtown. I've rescheduled with the managers for Thursday. I need you to come with me to meet a potential commercial real estate broker at 9. He was confused. He hadn't agreed to sell any property. When he arrived at the broker's office, the conversation was already advanced. The broker was talking about the development potential of the land under his flagship store. Clara spoke about unlocking equity. James sat quietly, then stood. "I'm not selling anything," he said, and walked out. In the car, Clara was furious. "You embarrassed me in there, James. This was for the family's future, for Michael's medical care. You have to start thinking practically." A chill settled in his gut that never fully left. He started checking the business accounts himself. He found recurring transfers he didn't recognize, $2,000 a month to a numbered LLC. When he asked Clara, she said it was for consulting fees for the partnership restructuring. She couldn't provide a detailed invoice. He told her to stop the payments. She said the contract was binding. He demanded to see the contract. It took her a week to produce a vague, two-page document he didn't remember signing. Then in December, he fell on a patch of ice on his driveway. He broke his wrist. It was a clean break, but at his age, it meant a surgery, pins, a long recovery. He was in the hospital for 2 nights. Clara visited constantly. She brought paperwork. Just some routine updates, James, while you're laid up. Better to keep things moving. One was a new durable power of attorney document. It named her as his primary agent with Michael as secondary. Standard procedure, she said. In case you need help with bills while your wrist heals. His hand was throbbing. He was on pain medication. He signed it. He later realized the document he signed in the hospital was far broader than the simple financial power of attorney he'd had for years with his lawyer. This one gave her authority over health care, residential decisions, and all asset management. The recovery period became a quiet takeover. Clara hired a live-in nurse, a stern woman named Gail, who reported everything, his meals, his phone calls, his mood, to Clara. James felt like a prisoner in his own home. His friends from the VFW stopped getting their calls returned. Clara told them he was too fatigued for visitors. She said it was for his health. She began talking about episodes of confusion. She told Michael his father was showing early signs of dementia, forgetting appointments, misplacing keys. Michael, struggling with his own health, believed her. The breaking point was a bank statement. James still had one private account Clara didn't know about, an old savings account from his first deployment with about $45,000 in it. The statement came in the mail, hidden amongst catalogs. He opened it. There were 2 large withdrawals he hadn't made, $20,000 on January 12th, another $15,000 on January 28th. The memo line read, "Property tax payment, Thorne residence." He hadn't paid property taxes from that account in 20 years. They were auto-paid from his business account. He called the bank. They said the withdrawals were authorized via phone by his power of attorney, Clara Thorne. He drove to the county assessor's office. The clerk confirmed the taxes on his home had been paid, but not from that account. The money was just gone. He confronted Clara that evening. He was calm, direct, showing her the statement. She didn't deny it. Her face changed. The charming daughter-in-law vanished. "You're not well, James. You're paranoid. You're forgetting things. That money was moved to a safer investment account. For your own good. You're not capable of managing this estate anymore. Look at you. You can't even remember signing the documents that protect you." The next morning, a process server was at his door. The nurse, Gail, let the man in. He handed James a thick packet. "James Thorne, you've been served." It was the petition, filed in Travis County Probate Court, in the matter of the guardianship of James Thorne, an alleged incapacitated person. The petitioner, Clara Thorne. The grounds, progressive dementia and financial imprudence leading to vulnerability and exploitation. The requested relief, a full guardianship of the person and the estate. She was asking the court to declare him incompetent, to appoint her as his legal guardian, to give her total control. His hands didn't shake. A lifetime of discipline held. He read the attached evidence, affidavits from the live-in nurse describing his confusion and agitation, a letter from a doctor he'd seen once for a physical, nodding patient seems forgetful, taken out of context. Financial records Clara herself had crafted, showing erratic spending. It was a masterpiece of manipulation. The final page listed all the assets to be placed under the guardianship. The house, the 3 businesses, all investment and bank accounts. Total value, $4.3 million. He called his old lawyer, the one who'd done his will before Clara entered the picture. The lawyer listened, then sighed heavily. "James, this is serious. These proceedings, they're stacked against the alleged incapacitated person. The court tends to err on the side of protection. You'll need a specialist in elder law, and you'll need one fast. The hearing is in 30 days. The specialist, a grim-faced attorney named Linda Rosario, laid out the battlefield. "She's done her homework, Colonel. The power of attorney you signed in the hospital is her weapon. It makes her actions look authorized. The evidence is flimsy, but it creates a narrative. Our job is to break that narrative. You will be evaluated by a court-appointed psychologist. We will present counter-evidence of your competence. We will attack her credibility and her financial motives." James asked the question burning in his mind. What are the chances? Rosario was silent for a moment. In this county, with a persuasive petitioner who's a family member and a financial professional, honestly, 50-50. It depends on the judge we draw. Some see through these family money grabs. Others rubber-stamp guardianships at the slightest hint of risk. They prepared. James underwent a battery of cognitive tests with a private neuropsychologist. He scored in the high-functioning range. He gathered years of clean business audits. He got affidavits from his store managers, his doctor, his friends at the VFW. He built a fortress of proof that his mind was sound. The court date arrived. The probate courtroom was wood-paneled and quiet, heavy with the weight of broken families. Clara and Michael sat on the other side. Michael wouldn't meet his eyes. Clara was composed, dressed in a sober suit, the picture of concerned duty. The bailiff called the case, number 73412, in the matter of James Thorne. The judge entered from his chambers. James looked up, and his blood went cold. The man in the black robe was older, his hair white, his face lined. But James knew him instantly. Captain David Vance, from the 101st Airborne. 35 years ago, in a dusty outpost, then Captain Thorne had pulled a wounded young Lieutenant Vance out of a burning vehicle after an IED attack. They served the rest of that rotation together. They hadn't spoken in decades. Judge David Vance took the bench, adjusted his glasses, and looked down at the case file. Then he looked up, his gaze sweeping the room. It paused on James. For a fraction of a second, there was a flicker, a barely perceptible tightening around the eyes, a minuscule tilt of the head. Recognition. Then his face smoothed back into judicial impassivity. He cleared his throat. "Counsel, are we ready to proceed on the petition for guardianship?" Clara's lawyer stood confident. "We are, Your Honor." James's attorney, Rosario, stood as well. "We are, Your Honor, and we vigorously oppose." Judge Vance nodded, looking down at the petition. "I see." He then looked directly at James, his expression unreadable. "Mr. Thorne, it's been a long time." The entire courtroom held its breath. James simply nodded. "It has, Your Honor." Vance's eyes went back to the file. "This petition alleges significant cognitive decline. It also involves considerable assets." He paused, tapping his pen once on the desk. A decision seemed to solidify behind his eyes. "Given the complexity and the history here, I'm not comfortable proceeding today. I am ordering an independent forensic evaluation of Mr. Thorne's capacity to be conducted by a neutral party selected by the court. I'm also ordering a temporary freeze on all non-essential financial transactions related to the listed estate. We will reconvene in 45 days for a hearing on the findings." It was a stay of execution. Clara's lawyer jumped up. "Your Honor, the petitioner has grave concerns about Mr. Thorne's current vulnerability. A freeze could harm the ongoing businesses." "Noted," Vance said, his voice firm. "The temporary guardian of the estate will be the court clerk's office. All disbursements require my signature. Petition denied for today. Court adjourned." The gavel cracked. As people stirred, Judge Vance stood, gathered his robes, and walked back toward his chambers. He didn't look back. James sat, stunned. He had just gotten a 45-day reprieve from a judge who knew him. But was it a gift or a trap? David Vance had just taken personal control of his finances. The man who now held his fate in his hands was a ghost from a war he tried to forget. And James had no idea whose side he was on. 45 days. James left the courtroom feeling like he'd stepped through a temporal rift. The past had just been appointed the referee of his future. His lawyer, Rosario, was pragmatic in the hallway. "He bought us time. Use it. The independent evaluation is everything, but we need to understand why he did it." Understanding why meant digging into David Vance. The disciplined soldier James remembered was now a powerful judge, but people change in 40 years. Rosario assigned a discreet investigator. The first report came in 3 days. Judge David Vance, 68, appointed to the bench 15 years ago after a career as a prosecutor. Known as a law and order judge, tough but fair. No major scandals. He chaired the county's elder abuse task force. That was interesting. He'd written op-eds about strengthening protections against financial exploitation. One line from an article jumped out. The courtroom should be a sanctuary for the vulnerable, not an auction house for their assets. Then the investigator found the personal connection. 5 years ago, Judge Vance's own father, a retired engineer, had been the subject of a contested guardianship. A cousin had petitioned for control, alleging dementia. Vance, then already a judge, had to recuse himself from the case. It played out in a different county. The cousin lost. The court found the father competent, but the process had been, according to a friend quoted in a local news piece, brutal and humiliating for the family. James stared at the report. Vance had seen this play from the other side. He knew the damage these petitions could inflict. Was his intervention a form of empathy, or was it something else? A chance to correct a past injustice he couldn't fix for his own father. The court-appointed forensic psychiatrist, Dr. Aris Thorne, no relation, was a wiry man with a penetrating gaze. His evaluation was scheduled for the following week. Clara tried to interfere. Her lawyer filed a motion to have her own expert present during the evaluation, claiming the need for transparency. Judge Vance denied it within hours. The court's expert requires independence. Motion denied. Another small victory, but each one felt like a tremor warning of a larger quake. The evaluation was a 6-hour marathon. Cognitive tests, memory games, hypothetical financial scenarios, questions about current events, personal history. Dr. Thorne was thorough and impassive. At the end, he asked James one final, off-script question. "Colonel, why do you think your daughter-in-law is doing this?" James didn't hesitate. For the money. She sees $4 million and a sick husband. She sees a problem she can solve by becoming the solution. Dr. Thorne merely nodded and closed his notebook. While they waited for the doctor's report, the financial freeze revealed its own story. With all accounts requiring Judge Vance's signature, a hidden paper trail surfaced. James's business accountant, finally freed from Clara's oversight, conducted a full forensic audit. What he found was systematic. The $2,000 monthly transfers to the mysterious LLC. They traced to a shell company that ultimately paid a commercial real estate firm, the same firm whose broker Clara had tried to set James up with. The firm was quietly optioning land parcels around his flagship store, assembling a block for a large development. Clara had been using James's money to fund the land acquisition around his own property, effectively increasing its sellability to that very developer. The $20,000 withdrawn from his private account. It was transferred to a joint account in Clara and Michael's name, then used as a deposit on a speculative land purchase in Colorado. An investment, she would later claim. But the most damning find was a document draft on the business computer, dated 2 months before the petition was filed. It was a proposed management and buyout agreement. It outlined a plan where Clara would assume 100% ownership of Fortitude Supply in exchange for a 10-year promissory note to James, with payments contingent on the business's profits. The note's value was pegged at roughly half the business's appraised worth. It was a blueprint for a forced sale at a discount. James had never seen it. Rosario compiled this into a counter-motion. They filed it with the court, a request to dismiss the guardianship petition due to bad faith and financial predation by the petitioner. They included the draft agreement, the audit findings, the LLC traces. It was a direct attack on Clara's credibility. The day after the filing, Michael showed up at the house alone. He looked gaunt, older than his years. James let him in. They sat in the living room, a cavern of silence between them. "She showed me the motion, Dad. The things they're accusing her of. They're not accusations, Michael. They're facts. The money is gone. The document was on my computer." Michael rubbed his face. She says it was a draft for a hypothetical, a worst-case scenario plan if you really did get sick. She says your lawyer is twisting everything. She's scared. Her career is on the line now. Her career, James's voice was quiet. She's trying to end my life as I know it. She filed a petition to have me declared a mental incompetent. What about my life, Michael? His son looked at the floor. I'm sick, Dad. The treatments, they're astronomical. Our insurance is maxed out. She's under so much pressure. She sees this estate as a lifeline for us, for our future. There it was, the core truth wrapped in a son's desperation. Clara's motive wasn't just greed, it was fear, channeled through avarice. She had convinced herself and partially convinced Michael that taking control was an act of familial salvation. This made her more dangerous, not less. A true believer is harder to reason with than a simple thief. There are other ways, James said, his heart aching. We could have talked. We could have structured help. You didn't have to try to bury me in a legal coffin. She said you'd never agree. She said you were too stubborn, too proud. Michael stood, his eyes wet. I don't know what's true anymore. I just know I'm stuck in the middle. After he left, James felt a profound weariness. The battle was cleaving his remaining family. He knew then that even if he won, he might lose his son forever. A week later, Dr. Thorne's report was delivered to the court and both attorneys. Rosario called James, her voice tight with excitement. It's a clean sweep. He finds you fully competent. No cognitive deficits consistent with dementia. He notes your memory is superior for your age. He states the petition's medical evidence is grossly insufficient and appears cherry-picked. He also includes a footnote. He interviewed Clara as part of his process. He notes her singular focus on asset management and her dismissive attitude toward your personal autonomy. This is gold, James. This is what we needed. For the first time, James allowed himself a flicker of hope. The neutral expert had seen through Clara. Surely the judge would see it too. But the legal system moves in opposing currents. The day after the report landed, Clara's lawyer filed a new explosive motion. They moved for Judge Vance's recusal. The grounds, the appearance of impropriety. The motion cited the personal, historical relationship between the judge and the respondent, referencing James's military service. It claimed this relationship could lead a reasonable person to question the court's impartiality. They attached an affidavit from a retired sergeant who claimed he remembered then-Captain Thorne saving Lieutenant Vance's life. It was a masterstroke. If Vance recused himself, the case would be reassigned to another judge, one without any personal history, one who might rubber-stamp the guardianship based on the initial, false narrative. If Vance refused to recuse himself, they could appeal, dragging the process out, draining James's resources. The motion put Vance in a box. Judicial ethics rules are clear. If your impartiality might reasonably be questioned, you step aside. The appearance of impropriety standard is deliberately vague. Vance had to rule on his own fitness to judge the man who once saved him. The hearing on the recusal motion was brief and tense. Vance sat high on the bench, his face a mask. Clara's lawyer argued passionately about the need for pristine justice. Rosario argued that the judge's actions so far, ordering the independent evaluation, freezing assets, demonstrated appropriate caution, not bias. She argued that removing him now would reward the petitioner for her own misconduct. Vance listened, asked few questions. Then he retired to his chambers to consider. The wait was agonizing. 30 minutes later, he returned. The motion for recusal, he began, his voice echoing in the silent room, is a serious matter. The court must not only be impartial, but must appear to be impartial. He paused, looking at James, then at Clara. However, the court also has a duty to see that justice is done, and that cases are not manipulated by procedural gamesmanship. The personal history referenced is decades old. My prior rulings in this case have been based on the evidence and the law, notably the lack of credible medical testimony supporting the petition. Therefore, the motion for recusal is He stopped. He looked down at a note a bailiff had just placed on his bench. He read it, his expression darkening. He took a deep breath. The motion is taken under advisement. The court will issue a written ruling within 48 hours. We are adjourned. Another cliffhanger. The investigator worked through the night. Why the sudden pause? The note, they learned from a source in the clerk's office, was a notification from the State Judicial Conduct Commission. Clara's lawyer had filed a formal complaint against Vance, parallel to the recusal motion, alleging bias. The commission had just acknowledged receipt. The pressure on Vance was now official and intense. The written ruling came 2 days later. At 5 p.m. It was a dense, 15-page document. Vance denied the recusal motion. He wrote that a long-ago military service connection does not, in itself, create a disqualifying bias. He criticized the petitioner for weaponizing the recusal process. It was a bold, defiant move. He was sticking to the case. But the final paragraph was cryptic. Nevertheless, in light of the extraordinary circumstances and the serious allegations involved, the court will appoint a special master to review all financial evidence and report directly to the court. This will ensure an additional layer of scrutiny and transparency. A special master, a court-appointed neutral expert to dissect the finances. This was unprecedented in a routine guardianship case. Vance was building a fortress of due process around James. But why? Was he being meticulously fair? Or was he constructing a record so bulletproof that his final ruling, whatever it was, could never be appealed? The special master was a former FBI forensic accountant named Elias Reed. He was given broad power to subpoena records from Clara, from the LLC, from the real estate firm. The investigation was now expanding beyond James's competence and into Clara's actions. Then the investigator delivered the final pivotal piece of the puzzle. It wasn't about Vance's father. It was about his sister. 8 years ago, Judge Vance's older sister, Deborah, mildly cognitively impaired from early-onset Alzheimer's, had been placed under guardianship. The guardian, a professional appointed by the court, had systematically drained her estate through inflated fees and dubious investments. By the time Vance and his brother discovered it, over $300,000 was gone. The guardian was prosecuted, but the money was never recovered. Vance had spoken about it only once, in a closed judicial conference, calling it a failure of the system I am part of. The picture snapped into horrifying focus. David Vance wasn't just a judge. He was a man who had seen the guardianship system fail his own sister, exploit her, rob her. He had then dedicated himself to reforming it from the bench. And now, he was presiding over a case that smelled, to his experienced nose, exactly like the one that had devastated his family. This wasn't about repaying a life debt from the desert. This was about preventing a crime he had witnessed before. He wasn't being James's savior. He was being the system's corrective mechanism. His motive was professional, maybe even obsessive. But this revelation created a new, terrifying vulnerability. Clara's lawyers, if they discovered this sister's story, could argue it created a different, deeper bias, a vendetta against petitioners, a predisposition to see exploitation in every case. They could use his personal trauma against him. James now held two competing truths. The judge on his case was possibly the only person in the courthouse who would fight to see the truth. But that same judge was a walking conflict of interest, whose personal history was a landmine that could blow the entire case apart. The 45-day reprieve was up. The final hearing was in 1 week. They had the psychiatrist's report. They had the audit. The special master was digging. But James now knew the real question wasn't about his mind or Clara's greed. The real question was whether David Vance could navigate the ghosts of his own past long enough to deliver justice, or if those ghosts would destroy them both. Clara's legal team didn't wait a week. They launched a two-pronged assault that changed the entire battlefield. First, they filed an emergency motion to suspend the special master, arguing his mandate was overly broad and prejudicial. Second, and more devastatingly, they filed a supplemental brief with the Judicial Conduct Commission. This one didn't just allege bias, it told a story. The brief laid out in careful detail the history of Judge David Vance's sister, Deborah. It described the guardianship abuse, the stolen $300,000, the professional guardian's prosecution. It quoted from Vance's own reported speech about the systemic failure. Then it connected the dots. Judge Vance, the brief argued, has a profound, personal, and traumatic association with guardianship proceedings. He views all petitioners through the lens of his sister's predator. This case is not about James Thorne. It is about Judge Vance's unresolved trauma and his desire for retroactive justice. His every ruling, the independent evaluation, the asset freeze, the extraordinary appointment of a special master, demonstrates a prejudgment that the petitioner is a criminal. This is the very definition of bias. It was a brutal, brilliant play. They had turned Vance's greatest virtue, his crusade against exploitation, into his fatal flaw. The motion to suspend the special master was a distraction. The real goal was to force the Judicial Conduct Commission to act, to pressure Vance to step aside to preserve his own reputation. The pressure worked with terrifying speed. Within 48 hours, the commission announced it was opening a preliminary inquiry. It was a formal investigation. No details were released, but the news leaked to a legal blog. Probate judge under scrutiny in high-stakes family feud. The story framed it as a bitter dispute, with hints of judicial overreach. The court of public opinion was now in session. Judge Vance did not recuse himself. He went silent. No rulings, no orders. The case froze again, but this time in a vacuum of dread. The final hearing was postponed indefinitely, pending the commission's preliminary inquiry. James was in legal purgatory. The asset freeze remained, which meant his businesses were hamstrung, unable to make major decisions without court approval. Clara, meanwhile, was not restrained. She was still his daughter-in-law, still living in his guest house, still managing the day-to-day operations of Fortitude Supply. She had lost the petition for now, but she had won the operational war. James's lawyer, Rosario, was furious. "This is a classic delay and bleed tactic, James. They can't win on the merits, so they're trying to disqualify the referee. And while the commission dithers, she's still in control of your life. We have to go on the offensive." The offensive took the form of Elias Reed, the special master. Vance's appointment order had not been vacated. The commission inquiry didn't formally stop his work. So Reed, a former FBI agent with a disdain for legal games, kept digging. And what he found went far beyond siphoned funds. Reed requested a meeting with James and Rosario. He arrived with a slim folder and the calm demeanor of a man who has seen the bottom of many wells. "Colonel, your daughter-in-law is not just financially ambitious. She is part of a network." He laid out his findings. The LLC that received the $2,000 monthly payments. It was one of several shell companies linked to a group of financial planners and elder law attorneys in 3 states. They had a pattern. One would identify an elderly client with assets and a health issue in the family. Another would facilitate the creation of restrictive trusts or powers of attorney. A third would, if necessary, file for guardianship, often using boilerplate medical affidavits from a handful of compliant doctors. The funds would be moved, fees would be extracted, and assets would be slowly consolidated into entities they controlled. Clara, Reed believed, was the identifier and facilitator in this group. Her move to Austin, her focus on elder financial security, her marriage to a man with a chronic illness, it wasn't a coincidence. It was a business model. Michael's condition was the perfect cover for urgency and emotion. "She didn't just target you, Colonel," Reed said quietly. "You were a target of opportunity, but you were also a test case. Your military background, your clear competence, your lack of immediate family, you were the perfect challenge. If she could get a guardianship over you, she could get one over anyone. It would be a badge of honor in that circle." James felt the room tilt. This wasn't about his money anymore. It was about a system. He was a battlefield in a larger war. The draft buyout agreement, the siphoned funds, they were just tactics. The strategy was control. "Do you have proof?" Rosario asked, her voice tight. "Circumstantial chains. Phone records showing frequent calls between Clara and two of the named attorneys in other states. Patterned financial flows. The same obscure medical evaluation firm used in 3 separate guardianship petitions, including yours. But here's the catch." Reed leaned forward. "To get the hard proof, emails, detailed transaction records, the kind that would hold up in criminal court, I need subpoena power. I need a judge. And the only judge who can give me, that is currently under investigation because of this case." They were in a perfect trap. The man who could unleash the investigation was being investigated himself. Then Michael came back. This time he was not confused, he was shattered. He found James at the main house, sitting on the porch. He didn't sit, he stood, shaking. "She left Dad, Clara. She packed a bag this morning. She said the liability was too high. She said she was going to stay with her sister in Dallas. She said to tell you she's withdrawing the petition." James stared at his son. It felt like a trap. Withdrawing. "She left this." Michael handed him a folded legal document. It was a notice of voluntary dismissal. Clara was dropping the guardianship case. No explanation, just a 1-page filing. Rosario was called immediately. She was skeptical. She's cutting her losses. The commission inquiry is shining a light she doesn't want. Reed's investigation is getting warm. By withdrawing, she makes the whole thing go away. The commission will likely drop its inquiry against Vance if the case is moot. The special master's mandate ends. She walks away clean. "And my money?" James asked. "Gone, the $20,000 from your private account. You could sue her civilly, but it would be a long, expensive fight. The monthly transfers, argued as authorized business expenses. She's betting you won't have the stomach for more litigation, and she's probably right." It was the worst kind of victory. She wouldn't get guardianship, but she had stolen from him, destabilized his life, poisoned his relationship with his son, and she would walk away. The system, gamed by her network, had allowed it. Justice was a tattered flag. But then the system surprised them. Judge David Vance broke his silence. He didn't accept the voluntary dismissal. Instead, he issued a 1-sentence order. Petitioner's notice of voluntary dismissal is hereby stayed pending review by the court. He was refusing to let her run. 2 days later, a courier delivered a thick envelope to James's lawyer. It was from the special master, Elias Reed. But it wasn't a report, it was a request. Reed had used his existing authority to subpoena Clara's personal email from the time she moved to Austin. He'd found something, not about the network, about the judge. He included a single printed email. It was from Clara to an old college friend, dated 8 months ago before the petition was filed. The subject line was long shot. In it, Clara wrote, "The old man is stubborn, but the business is ripe. The real play might be the probate court. I did some digging. The judge who would likely get the case is a David Vance. Get this, he served with my father-in-law, saved his life apparently. I don't know if that's good or bad, might be leverage, might be a problem. But it's a connection." James read it twice. Clara had known about the connection between him and Vance from the very beginning. She had researched it. She had considered it leverage. This changed everything. It meant her later cries of judicial bias were completely cynical. She had been aware of the relationship and only chose to weaponize it when Vance's rulings went against her. This was proof of bad faith that even the Judicial Conduct Commission could not ignore. Rosario filed the email with the court immediately, with a blistering accompanying motion. She argued that Clara had committed a fraud on the court by hiding her prior knowledge of the judge's relationship and then using it to attack his impartiality. She asked for sanctions. She asked for the petition to be dismissed with prejudice, meaning it could never be filed again. And she asked for the special master's findings to be referred to the district attorney's office for criminal investigation. The reaction was seismic. The Judicial Conduct Commission, presented with evidence that its own inquiry had been manipulated, suspended its preliminary investigation of Judge Vance. Clara's lawyers filed a frantic motion to withdraw from the case, citing irreconcilable differences with their client. It was the legal equivalent of abandoning a sinking ship. And then Judge David Vance spoke. He called an emergency hearing, not in his probate courtroom but in the main ceremonial courtroom, a signal of gravity. The room was packed. James sat with Rosario. Clara was not present. Her lawyers sat at their table looking profoundly uncomfortable. Michael was in the back row, his face pale. Judge Vance entered. He looked tired, but his eyes were clear and sharp. He did not sit. He stood at the bench, his hands resting on the wood. "This case," he began, his voice low but carrying to every corner, began as a petition for protection. It has revealed itself to be a scheme for predation. The evidence before the court demonstrates a calculated campaign to isolate, manipulate, and financially exploit James Thorne. The petitioner, having failed to secure control through persuasion, sought it through a legal proceeding she knew was baseless. When that failed, she sought to corrupt the proceeding itself by attacking the court's integrity. He paused, looking directly at James. "Mr. Thorne, you have been failed by someone who should have been family. You have been failed by a system that is too slow to see such schemes taking root. For that, you have my apology." He then turned his gaze to the empty petitioner's table. "The petition for guardianship is dismissed, with prejudice. The temporary freeze on assets is lifted, effective immediately. The court finds that the petitioner, Clara Thorne, acted in bad faith and with unclean hands. The court refers the full record of this matter, including the special master's findings, to the Travis County District Attorney for investigation of potential criminal acts, including theft and fraud on the court." He brought down the gavel, a clean, sharp crack. It was over. James was free. The legal machinery that had been grinding toward his destruction was now, suddenly, turning against his accuser. He felt no triumph, only a vast, hollow exhaustion. As people filed out, Vance's bailiff approached James. "His Honor would like to see you in his chambers for a moment, Colonel, if you're willing." Rosario gave a cautious nod. James followed the bailiff. He was shown into a small, book-lined office. Judge Vance was removing his robe. He looked older without it. "James," he said, "not Mr. Thorne." He gestured to a chair. "This isn't a judicial meeting. This is between two old soldiers." James sat. "You took a risk," he said, "sticking with the case." Vance poured 2 glasses of water from a pitcher. "I did, but that email your lawyer found, that was the key. It showed her pattern. It showed she saw people as tools, connections as leverage. She saw our history as a factor to be managed, not a bond to be respected." He handed James a glass. "What happened to my sister? It made me vigilant. But it didn't make me biased against all petitioners. It made me biased against liars, and she was a liar." "What happens now?" James asked. "To her?" "That's up to the DA, but she'll never work in financial planning again. Her license will be revoked. She may face charges. Your son is broken," James finished. "I don't know if I can fix that." Vance was silent for a long moment. "Some battlefields," he said finally, "you just have to walk away from. The war is over. You won. Now you have to figure out what peace looks like." James left the courthouse into the blinding Texas sun. The weight was gone, but the landscape of his life was scarred. The legal victory was absolute. The personal wreckage remained. He had his freedom, his fortune, his name cleared. But as he drove back to his empty, silent house, he understood that the real battle was just beginning. Not in court, but in the quiet space of a life that had to be rebuilt from the ground up, knowing what he now knew about the people he had let in, and the shadows that could hide behind a smile. The war for his estate was over. The war for his future was about to begin. Peace, James Thorne discovered, was not a destination. It was a daily construction project. The first task was dismantling the architecture of control Clara had built within his own home. The live-in nurse, Gail, was gone the day after the dismissal. James changed the locks on every door. He hired a security firm to audit his home systems and remove any monitoring software Clara might have installed. He found a listening device in the living room lamp, a small, battery-powered thing. He dropped it into a glass of water and watched it die. The legal victory was complete, but the financial cleanup was a maze. With the asset freeze lifted, his accountant and a new, vetted financial advisor began the painstaking process of unwinding Clara's maneuvers. The $20,000 from his private account was gone for good, a theft the district attorney would add to their case. The monthly transfers to the LLC were stopped. The special master's full report, now public record, provided a roadmap for civil suits against the shell companies and the real estate firm. James decided not to pursue them. "More lawyers, more time," he told Rosario. "I want to be done." His primary focus was Fortitude Supply. Clara's daily management had left a mark. She'd fired one longtime store manager who questioned her financial moves. She'd changed suppliers to more expensive vendors who, the special master noted, kicked back a percentage to one of her network's shell companies. James spent 2 weeks visiting each store, reinstating the fired manager with back pay, renegotiating supplier contracts, and assuring his staff that the shadow war was over. The business was his again, not just on paper but in spirit. Then there was Michael. His son called once a week after the dismissal. He was in Denver staying with a friend. His voice was hollow. "She cleaned out our joint accounts, Dad, left me with nothing. The medical bills," he didn't finish. James felt a complex ache, anger at his son's gullibility, pity for his illness, and the unshakable pull of fatherhood. "Come home, Michael," James said, the words surprising him as much as they surprised his son. "Not to the guest house. We'll get you an apartment nearby. We'll figure out the medical care, but you come alone." There was a long silence. "Why would you do that after everything?" "Because you're my son," James said, his voice rough. "And she counted on me abandoning you. I won't give her that victory too." Michael returned to Austin a week later. He was thinner, defeated. James rented him a modest, accessible apartment near a good medical center. He set up a strict, trustee-managed fund to pay for Michael's treatments and living expenses. The money was protected, dispersed by a professional, not handed over. It was help, but it was not a blank check. Trust, James had learned, was not an absolute. It was a carefully monitored border. The criminal case against Clara moved slowly but with grim inevitability. The Travis County District Attorney, armed with the special master's report and Judge Vance's referral, convened a grand jury. 6 months after the dismissal, Clara was indicted on 3 felony counts: theft from an elderly person, fraud, and forgery. The network she was part of was also exposed. Investigations opened in 2 other states. Her license as a financial planner was permanently revoked. She pleaded not guilty, but the evidence was formidable. She remained free on bail, awaiting trial, her reputation in ashes. Judge David Vance's role did not end with the gavel. The email proving Clara's prior knowledge of their connection had not only saved him from the Judicial Conduct Commission, it had made him a symbol of resilience against court manipulation. He used the platform. He drafted and championed a new set of local court rules, known informally as the Thorn Provisions. They mandated that in any guardianship petition, the petitioner must disclose any prior knowledge of a personal connection to the assigned judge. They also required a mandatory in-person review by a court investigator within 72 hours of any ex parte temporary guardianship order, to prevent the isolation play Clara had attempted. The story, of course, leaked to the press. Not the full, sordid detail, but the compelling headline: "War hero Colonel beats back daughter-in-law's takeover bid. Judge who served with him presides." It was a viral sensation. James refused all interview requests. He had no interest in being a poster child for elder abuse. The victory was private. A year passed. The rhythm of James's life recalibrated around a new, cautious normal. He worked at his business. He had dinner with Michael every other Sunday, a strained but improving ritual. He reconnected with his friends from the VFW. The hollow feeling in his house gradually filled with the quiet satisfaction of autonomy. Then, an envelope arrived with the official seal of the Texas state capitol. It was an invitation to provide testimony before the state Senate's Judiciary Committee. They were considering a bill to reform the guardianship process statewide, inspired by Vance's local rules. The chair of the committee had personally asked for him to speak. James almost declined. The thought of reliving it in public made his skin crawl, but Rosario counseled him. They don't want the dramatic story, James. They want the facts, the loopholes, the way the paperwork can be weaponized. You can help close the door for the next guy. He agreed. The hearing room was imposing, all dark wood and microphones. He wore his old dress uniform, the ribbons a silent testament to a different kind of service. He did not talk about betrayal or fear or his son. He talked about procedure. He explained how a broad power of attorney signed under duress can become a key to a kingdom. He described how the evidence of incapacity can be manufactured from normal forgetfulness. He outlined the delay tactics that can drain an elderly person's resources before they ever see a trial. He was clear, factual, and devastating. As he finished, the committee chair, an older senator, leaned into his microphone. Colonel Thorne, based on your experience, what is the single most important reform? James didn't hesitate. A mandatory state-funded advocate, a lawyer whose only job is to represent the alleged incapacitated person from the moment the petition is filed. Not a guardian ad litem who reports to the court, but a fighter who reports to the client. Someone who can't be paid off or influenced by the family. You can't expect a 70-year-old man, suddenly served with papers that say he's lost his mind, to also become a legal strategist. That's the vulnerability. That's what they exploit. There was a pause, then a soft ripple of applause from the gallery. The bill later passed with an amendment funding a pilot program for exactly that, a state public defender's office for guardianship respondents. They called it the Thorne Advocate Provision. The final surprise came on a cool autumn afternoon, almost 2 years to the day after the petition was first served. James was at his flagship store, reviewing inventory. His assistant said a visitor was asking for him, not a customer. James walked out to the showroom. Standing there, looking older and wearier but with his back straight, was David Vance. He was out of his robe, in a simple jacket and slacks. "Judge," James said, extending his hand. "Just David today, James," Vance said, shaking it firmly. "I'm retired as of last month." They went to a small diner nearby. Over coffee, Vance explained he'd left the bench. "That case was the last big one. It showed me the system can be fixed, but not from inside one courtroom. I've joined a nonprofit. We train those advocates you talked about. We're building the program you helped create." James smiled, a genuine one. "So you're still cleaning up the battlefield?" "Trying to," Vance said. Then he grew quiet. "There's something I never told you. That day in my chambers I said I wasn't biased. That was true, but I was invested. When I saw your name on that petition and read the flimsy evidence, I didn't just see a case. I saw a chance. A chance to prove that the system could work, that it could catch a predator instead of empowering one. For my sister, maybe for my father. I used your case, James. I used it to prove a point to myself." James sipped his coffee, letting the admission settle. "You used the tool you had," he said finally. "And it worked, for both of us. Maybe for a lot of people. I can live with that." Vance nodded, relief softening his features. They parted with a promise to have lunch again, not as judge and respondent, but as two old men who had, in a strange way, saved each other. James drove home as the sun set. His house on the hill was no longer just a fortress he defended. It was a home he inhabited. He had his business. He had a cautious, healing connection with his son. He had, improbably, a friend in David Vance. And he had a legacy he never intended, a law that might protect others. He sat on his terrace, the same place where he'd felt so isolated during the fight, and looked over the city lights coming on. The war was over. The peace was built day by day on a foundation of hard-won trust and unwavering boundaries. He had taken his life back not to hoard it but to live it on his own terms. The final victory wasn't in the courtroom dismissal or the criminal indictment or even the new law. It was in this quiet moment, alone yet not lonely, free and at peace. The system had failed, then it had corrected, and he had survived its storm. Now he was simply living. And for a man who had faced losing everything, that was the greatest payoff of all. The story of James Thorne is a victory, but it is not an anomaly. It is a stark map of a battlefield that exists in plain sight, in probate courts across the country every single day. Guardianship, or incompetency proceedings, are among the most powerful tools in our legal system. Designed as a shield for the vulnerable, they can, with the right or wrong hands, become the sharpest of swords. What happened to James reveals the fragile hinges on which a person's autonomy swings. A single signed document under duress, a cherry-picked medical opinion, the strategic isolation from friends and allies. These are not dramatic, fictional maneuvers. They are the documented tactics found in hundreds of cases of alleged elder exploitation. The U.S. Government Accountability Office has repeatedly highlighted the risk, noting that guardians have misappropriated millions from those they were sworn to protect. The coincidence of the judge, a man from the patriarch's past, is the twist that captures our attention. But the deeper truth is that such a coincidence should not be necessary for justice. A system should not rely on fate or personal history to function correctly. James Thorne's case had a rare element, a judge with both the personal insight to see the scheme and the professional courage to confront it. For every case like his, how many others proceed unchallenged, where no one connects the dots, where the gavel falls on a life quietly dismantled? The reforms born from his ordeal, the Thorne provisions, and the Advocate Pilot program are incremental fixes to a vast and vulnerable frontier. They are necessary band-aids, but the underlying disease is a combination of greed, opportunity, and a legal process that can prioritize procedure over people. The greatest defense, as James learned too late, is not wealth or even family. It is vigilance. It is the careful curation of one's legal documents. It is the questioning of sudden help from those who stand to gain. It is the understanding that the word family in a courtroom can be a description of biology, not a guarantee of benevolence. James reclaimed his life. Clara faces trial. A judge retired to train advocates. A law was changed. This is the best possible ending to a story that often ends in silent loss. Yet the question lingers: how do we as a society better balance the absolute necessity of protecting those who are truly incapacitated with the sacred right of others to live free, autonomous lives, even if they are old, even if they are stubborn, even if they make mistakes with their own money? There is no easy answer. Only the constant, difficult work of building a system with better alarms and fewer trapdoors. If you found this deep dive into the hidden world of contested guardianships compelling, please show your support. Like this video to help others find it, and subscribe to the channel for more documentaries that unravel the complex, real-life stories where law, money, and family collide. We want to hear from you. Have you or someone you know ever encountered a situation where legal protection felt like a threat? Share your impressions and experiences in the comments below. Your perspective adds to this crucial conversation. Thank you for watching.